New this morning, Alabama judges may soon have more authority to deny bail to suspects of certain violent crimes.
In order for that to happen, Alabama voters must approve of a constitutional amendment. It's called Aniahs Law on November 8th.
This morning, we have a live interview with University of Alabama School of Law professor Jenny Carroll.
Good morning, Professor Carroll. Thank you for joining us right now.
Good morning. My pleasure.
I want to ask you, what are the main sources of conflict between supporters and opponents of the proposed Aniahs Law constitutional amendment?
Yeah, so I'm not sure if it's really a conflict. I mean, the question is whether or not Alabama wants to amend its state constitution to go from presuming the right to bail for all charges or for any offender to restricting that presumption for certain types of violent felony offenses, Class A felony offenses. I want to be clear when I say that Alabama's current constitution does have a presumption of a right to bail. That doesn't mean that judges are allowing everyone out on bail. Judges are still engaging in bail hearings and making decisions on an individual basis as to whether or not individuals should be released pending trial.
Okay, and this is something we've been following this morning, and one more question that we have is a little bit of background for this law. Can you tell us a little bit? This is, again, sorry, I'm like losing track of my words. We followed Aniah Blanchard's story. Can you tell us a little bit about the background of what supporters are trying to push?
Sure. So, I mean, there's no denying the tragedy of Aniah Blanchard's murder. She was a young woman who was murdered in Auburn by a man who was out on bail for not only very serious offenses, but very similar offenses to the ones that he is accused of committing against Aniah Blanchard. And the fact that he was out on bail caused people to question whether or not judges were striking the proper balance between concerns about safety for the community and ensuring that those who are just accused of crimes are permitted to be out of custody while they're awaiting their trial. So when Aniah's bill was first proposed, the theory was that judges, instead of presuming this right to bail, should actually be more restrictive, that we should flip this presumption so that we presume no right to bail for very serious violent felonies. So again, this is a very limited construction of this flip presumption, right? It's not for every type of offense. It is for people accused of Class A violent felonies. And there's a list that's actually articulated in Aniah's Law. And that law was the product of a really legislative compromise and conversation. I actually testified at the committee hearing about the law, about the effect it would have within our state. But I mean, it's really premised on this idea that in order to stay safe, we should think about whether or not we release people pre-trial. Now, I think what's complicated in that conversation is it is important to keep in mind that the man who is accused of murdering Aniah Blanchard his bail was set at nearly $1 million. I have every confidence, I was not at his bail hearing, but I have every confidence looking at that bail amount that judge did not anticipate that he would readily be released. I think that judge thought that he was setting a bail amount that was appropriate given the gravity of the accusations against him at that point, right? This is before he murders Aniah Blanchard. And that he wouldn't be able to meet bail, that he would remain in detention. And I think that was a good assumption. I also think it's tricky because for every one of these cases that we can point to where it's a tragedy, and again, I'm not saying it's not a tragedy. This family has suffered. Our community has suffered as a result of this crime. But for every one of these cases where this happens, there are literally hundreds of other cases where judges make a decision to allow pretrial release, or they make a decision to set a bail amount that does not result in pretrial release, and the community remains safe. So I think it's important to remember that Aniah Blanchard's case is really an exceptional case rather than an ordinary case when you're thinking about this law.
Oh, wow, that's definitely an interesting point of view when you're talking about the judge and what he could have been considering. Now, is it arbitrary or does it violate the idea of innocent until proven guilty to deny bail to suspects accused of these types of crimes, but allow bail for suspects charged with other crimes?
Yeah, so you have hit on what is the big debate around bail. So the US Supreme Court has repeatedly said that bail is not punishment. So it doesn't violate that due process requirement of presumption of innocence, which is what you're referring to. However, the court has said, bail cannot be arbitrary, that bail should be set to accomplish whatever the state's articulated purposes are. So in a case like this, all Alabama is doing is saying there are certain types of offenses that we feel indicate a particular type of dangerousness. And if a person is accused of that type of offense, we are going to make a presumption that they cannot be safely released on bail. Now, that's not to say a judge couldn't release them on bail. A judge could still hold a hearing and make a determination that bail was appropriate. But the presumption is that it is not. The current presumption is that the state should not be able to take away people's liberty pre-trial in just ordinary circumstances in Alabama. And I do want to stress, in Alabama, even though we currently have this presumption of a right to bail, people are still often detained pre-trial. They simply can't afford the bail that is set. And so, I think another question that voters are going to have to weigh out is this the right solution? So flipping the presumption, I think will produce more pre-trial detention, if I'm being completely honest. However, I don't think that without this flip of the presumption that it's like we're seeing less pretrial detention. I think we still have a lot of pretrial detention in our state.
Yeah.
And so I think we could have conversations about, do we want to give judges more time to thoughtfully consider what conditions will safely allow people to be released back into the community, knowing that they won't present a danger to citizens, but also that they'll return to court for future proceedings. And again, in the vast majority of cases, that's exactly what happens. If you look at rates of recidivism, which means reoffense, or you look at rates of failure to appear in systems that either have no bail or have very limited cash bail requirements, their rates of recidivism and failure to appear don't go up significantly. And so I think the suggestion, and in fact, in many jurisdictions, they remain exactly the same. So I think this idea that bail serves a safety function is perhaps exaggerated. And so, I think we can have a conversation as voters about whether or not this is the solution we want to pursue.
Well, Professor Carroll, thank you so much for joining us. In my opinion, or after talking to you, I've definitely feel like I've gotten all aspects of ways to view this now big topic that's approaching for Alabama voters.
Well, thank you so much. I appreciate that.